Hey everybody, welcome to week 7. We're making progress. We're just about halfway done with the course. So let's do the last part of our second section of the course so we can get ready for our quiz that is due by the end of this week. So you got a lot of important takeaways from today's lecture. Let's go. All right, learning objectives, pretty general. I'm not even going to talk on these. Just here they are. Let's get to it. All right, our federal court system. It's very important to remember that the federal court system in the United States has 3 tiers to it. And we're going to go through these tiers. We're going to visualize this and get some key takeaways that we have to remember. So first off, one key takeaway, 3-tiered court system, district, circuit, and supreme. That is an important sentence to remember. There are roughly about 890 federal judge posts at all levels, including the Supreme Court, district, and federal courts. About 94 of them are designated to the district courts. This is where you have one judge for each trial. This is your trial courts. These are the first. This is the first court you will engage with for criminal or civil trials. And again, one judge per case. You don't have to remember the numbers for each set of courts, but it is important to remember the tiered system and how generally how they operate. So one judge per case, trial courts on the district level. Then you move up to the federal circuit courts. This is also known as the appeals courts, the appellate courts. This is where you have panels of 3 judges for each individual course. This is where if you've already been through the district courts and you want to appeal your case, if you do not approve of the ruling, if you believe you've been wrongfully convicted, or the civil case did not go the direction that you believe it should have gone, you can appeal it and then make it to the circuit courts. You will have 3 judges on this panel. And then if you appeal the circuit court's ruling and the Chief Justice of the United States is willing to hear your case, you can make it to the Supreme Court. This is the highest court in the land. There is nothing beyond this, and their ruling is the final say through the judicial system. We have 9 justices on the Supreme Court. They are not called judges because they are justices. They have made it to the final step. This is, once again, the highest court in the land. There are 9 justices, and we have had a fluctuating number of justices throughout American history. But since 1800s, we've been at 9 quite consistently. Our Constitution, Article 3, Section 1 says, quote, it establishes the Supreme Court and allows Congress to create lower federal courts, set the tenure of judges to life, contingent upon good behavior, ensuring an independent judiciary. I thought that was a direct quote in my notes, but it is not a direct quote. My bad. All right, so let's look at this. This is a visualization of our 3-tiered court system. You see at the bottom level of the pyramid, the U.S. district courts alongside the U.S. tax courts. And again, if you make it past this level, if you have a ruling from these courts and you appeal it, you can make it to the U.S. Court of Appeals. It's in the name. It makes sense. This is where you also have claims courts, Court of International Trade. This is where you really begin to see some federal cases as well, while U.S. district courts are almost exclusively state level. And then, of course, if you appeal the ruling that the U.S. Court of Appeals provides, you can then make it to the Supreme Court. So a 3-tiered system. All right. So it's important to also make sure we understand some very basic distinctions between state and federal court systems. Some things that we might overlook and not think deeply enough to understand. It's pretty simple that when you look at the state and the federal level, we have 2 different sets of laws. We even have 2 different constitutions, as all states have their own independent constitution as well as federal constitutions. In the state of Montana, our constitution is one of the most noteworthy, is ratified in the 70s and has one of the only states that has a focus on a clean environment, which progressed a recent lawsuit a few years ago. Fascinating. That caught some national attention. So, and the basis of the ruling in that Montana Supreme Court ruling was founded off of the text of our state constitution. And that's an important takeaway. State governments, state courts have to reference the state constitution and not the federal constitution, while the federal judges have to exclusively reference our federal constitution. Additionally, we see on the federal level, all judges, every single one of them, is to be appointed by the president and approved by the Senate. Now, when you look on the state level, we have a bit more diversity in how we appoint judges. There are 2 ways. First, you can have them appointed by a governor, very similar to the federal level. Just remember, the governor is the head of the executive on the state level, so it makes sense that this power would be granted to the governor. But some states, like Montana, choose to have nonpartisan elections instead. So you'll see your ability to vote for your Supreme Court justice on the state level. This is for your Montana Supreme Court. We currently have an election going on right now. You've probably seen the ads about your Supreme Court choices. It is also worth noting most criminal cases will occur on the state level, and then if you appeal your rulings, you can make it up gradually. When you look in the state of Montana, you see judicial power distributed among many courts. The Montana Supreme Court with the Chief Justice and 6 Associate Justices. So in the Montana state level, we have 7 justices. I will not quiz you on that, but a noteworthy takeaway. We also have the state level district courts. We have Workers' Compensation Court, the Water Court, the Court of Limited Jurisdiction, which includes justice courts, municipal courts, and city courts. You don't have to remember that necessarily, but it is important to hear it. All right, types of cases. Now, this is where we have to get some basic foundational differences. There are 2 types of cases you can engage with, civil or criminal. Now, let's just make sure we understand the basic foundation that when you have a criminal case, you have a higher burden of proof than in a civil case. Civil cases often result into monetary damages, injunctions, specific performances, like selling off parts of your company if that is a part of the ruling, while criminal cases often result in incarceration, fines, probation, community service if it's something more minor. Now think of it simply. Criminal cases, you have to be convicted. You have to be caught committing a crime, and this is where you get convicted of that crime. These crimes, have a significant range from murder, theft, assault, traffic offenses, various other possibilities when it comes to criminal cases. Now, civil cases, a little different. Some examples are breach of contract, personal injury, property disputes, family law issues. One example of the contrast between a criminal and a civil case is a case that caught this nation's attention many years ago when some of you, most of you, including myself, were not even born. So sorry for those older students that just made me see revealed how outdated I am. But the case I'm talking about is the OJ trials. OJ in the 90s was convicted for murder, was sentenced for murder, but not sentenced, was tried for murder. I'm getting my words out eventually, and then was not sentenced or not convicted guilty. Now, he was tried in a civil case. The civil case had a lower burden of proof, and they were able to convict O.J. Simpson, and this resulted in monetary damages to be paid out to the family of the victims. So we see the difference between civil and criminal consists of the difference in burden of proof, the possible outcomes, as you see incarceration and fines, and then you see monetary payouts to the victim when it comes to civil cases, and the different cases the different circumstances they require. All right, now this is just a quick one. I will not be quizzing you on this, but I think it is important to have a discussion and for me to provide you this information. So our amendments in the Constitution cover a lot of different things, but I've tried to concentrate all of the amendments that relate to our judicial branch. So the 4th Amendment, this provides protections against unreasonable search and seizure. This requires a probable cause or a warrant for any officer to search you, your persons, your vehicle, or anything of that nature. 4th Amendment is something you would learn in high school street law courses if you ever took one of those, where you would understand how to utilize our Constitution to defend yourself. This is one you do not have to allow individuals to search you in any given moment unless they have probable cause or a warrant. Now, additionally, we see the 5th Amendment. This is a right to due process, protection against double jeopardy. Double jeopardy, you can't be tried for the same crime twice. And you can't incriminate yourself. You have the right to not speak against yourself in a court of trial, in a trial, and in any circumstance. You've heard people yell out, "I plead the 5th." If you watch the old Chappelle show, you know, "I plead the 5th." It's a great skit. Also, the 6th Amendment. This is where you have the protections of fair and speedy trials, public trials, an impartial jury of your peers. This also gives you your right to be informed of your charges, right to confront witnesses under the correct circumstances, and the right to right to counsel, right to have a lawyer provided to you if you do not have one. We also fast forward to the Seventh Amendment. This is a right to jury trial in federal cases, expanding this jury right that's provided on the state level to the federal level as well. And it's important regarding the distinction between civil and criminal cases within our court system. Our Eighth Amendment protects against excessive bail, excessive fines, the classic cruel and unusual punishment quote. This is important because it makes sure you cannot have excessive penalties for your crimes. And this also relates to how you interpret our Constitution, as you can either interpret it strictly or loosely, cruel and unusual, or cruel or unusual. We also look at the Fourth Amendment. This expands due process protections and equal protection under the law, making equal protections applicable to state actions as well under their incorporation doctrine. This is one of the most litigated parts of the Constitution. This gives the courts the power to review state laws that may infringe upon individual rights, and has a wide range in how we operate within our court system. So you see our judicial system has a lot of guidelines, especially within our Constitution, that restrict and limit and protect individuals' experiences within this system. Now, let's talk about judicial appointments. These are those hundreds of federal judges that stem from the district, circuit, and Supreme Courts, and they are all appointed by the president. Not any single president, but they are appointed by the sitting president whenever there is an open post. Now, presidents make the appointments, but our Senate has to approve these appointments. The Senate Judiciary Committee debates the appointments. And remember, it is important the influence that committees have on our federal level before anything gets voted on within the House or Senate. They tend to gravitate towards a committee first. Remember, that's the second step in the 4 steps of passing legislation, which we covered last week. So the president makes judicial appointments. The Senate Judiciary Committee debates the appointees. And then we have the Senate voting on the appointee. These appointments are lifelong appointments. We do not have any requirements or qualifications for being a judge or Supreme Court justice, except for we trust that the president will only select people that have the general hypothetical qualifications for this post. Now we see our current Supreme Court has 6 Supreme Court justices appointed by Republicans, 3 by Donald Trump, 3 by George Bush, and 3 appointed by Democrats, 2 by Obama, and 1 by our most recent Joe Biden, our current president, Joe Biden. Now, it's just over time, we've seen in recent years, George W. Bush appointed 322 federal court judges, Bill Clinton a little bit more in his 2 terms, 367, Obama in his 2 terms, 329. In Trump's single term, he appointed 226. And we also can see Bill Clinton appointed 66 appeals courts, Bush 62, Obama 55, and Trump 54. All the 3 presidents prior were 2-term presidents, while Trump was a 1-term president, finding it just fascinating how timing can reveal whether you will have significant or restricted appointment powers, in addition to the use of the filibuster within the Senate, which stifled Barack Obama's abilities to appoint numerous individuals to these courts, which resulted in Harry Reid utilizing the nuclear option, which we covered last week. So let's talk about the Supreme Court, get a general understanding. So the Supreme Court itself does not have any enforcement powers. The enforcement powers come from the other branches of government. We also see we have a system within the, there is a system within the Supreme Court, which is there are 9 justices, 9 total Supreme Court justices, as you see below, with 1 Chief Justice of the Supreme Court. Our current Chief Justice is John Roberts. We will look into what the Chief Justice does in just a moment. The Supreme Court hears about 80 cases a year. And again, remember, it was not always 9 justices. There were not always 9 justices on the Supreme Court. Originally, the court had just 6 justices. Then in 1801, the number increased to 7 to break ties. 1803, it was reduced back to 6 justices because of conflict with the number 7. 1819, it grew back to 7 once more. And then 1837, just a few years later, we increased the number to 9 justices. One of the cases of stacking the courts in our history, the only one. And then in 1863, for just a short 3-year period, we increased the courts to 10 seats. The exact reasoning I am not aware of, but it quickly was retracted back to 9 and permanently maintained at 9 from 1869 to the very present. Now we can see that our Supreme Court has lifelong terms. Remember that important thing, and there are no requirements to becoming a Chief Justice except for the fact that you have to be appointed by the President. Our current Supreme Court has three justices appointed by Democratic presidents and six justices appointed by Republican presidents, and we'll go into detail later on how there are arguments about how this influenced the current ideology maintained within the Supreme Court. So, again, I'm just kind of reiterating a point, but the requirements to becoming a Supreme Court justice, well, there are absolutely none. You do not have to have a law degree. You do not have to be of a certain age. You do not have to have been a judge in the past. You just have to be appointed by the president. Our Constitution says, quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts, and the Congress may from time to time ordain and establish. The judges both of the Supreme and inferior court shall hold their offices during good behavior, and shall, as stated, receive for their services a compensation which shall not be diminished during the continuance in office." Some of the criteria utilized by George Washington when he appointed the first round of justices, including John Jay, our first Chief Justice, which we covered early on in the course, was that they had to support and advocate for the U.S. Constitution. They had to have had distinguished service in the American Revolution. Fascinating point. They have to have active participation in their political life of a particular state or the nation as a whole. They had to have prior judicial experience on lower tribunals, so they had to be a judge or lawyer of some sort. And they needed to either maintain a favorable reputation with his fellows or personally know Washington himself, showing the requirement for relationships with the presidency. They also have to be geographically suitable. The original Supreme Court consisted of circuit riders. And finally, his last requirement was they need to maintain a pure love of the country. But let's talk about two approaches to interpreting the Constitution that is represented by different Supreme Court justices over time. And we're going to look at, we will also revisit this case, but we're going to look at one very briefly to understand how this how this difference in ideology represents itself. So we have originalism and living constitutionalism. Originalism is when the meaning of the constitutional text is fixed, and that it should bind constitutional actors. It should be interpreted exclusively how it was written. A good example of this is under our 8th Amendment, you cannot have cruel and unusual punishment. Well, if you're interpreting it strictly how it was written, you can't have cruel and unusual, but you could have cruel or unusual because of their choice of the word "and" instead of the choice of the word "or." So you could have a extremely strict way of interpreting the Constitution, and this is generally represented under the general title of originalism. Now, you can also have living constitutionalism. This means that the constitutional law can and should evolve in response to changing circumstances and values. Our Constitution should be a guiding principle, but we should also consider the fluctuating challenges that the state faces. That's what the living constitutionalists echo, while the originalists echo that we must maintain strict interpretations and exclusively rule off of what we believe our founding fathers meant. Now, this was very representative in the District of Columbia versus Heller 2008 case. This case was regarding gun ownership, private gun ownership, and they, on the originalist side of the ruling, which was the majority ruling, they used an 1800 text to defend the identified original intent behind a well-regulated militia, and they provided protections for gun ownership for personal self-defense. A good result, a good ruling, but it is worth noting that this revealed their strict interpretation of what our founding fathers meant. They cited text from the 1800s that signaled what our founding fathers originally meant when they wrote the text, and that was a foundation for their text, for their sentiment. Now, when you look at, I'm sorry, I just want to go through my notes. I have a direct quote here. But when you look at the living constitutionalists, uh, the dissent was provided by John Paul Stevens, and Stevens aligned with a more living constitutionalist approach, argued that the Second Amendment should be understood in the context of modern societal needs. I believe the original purpose of the amendment was to ensure state militias could defend against federal overreach, not to protect an individual's right to own firearms when related to military services. So that is this really revolved around the debate between individual ownership rights or collective ownership rights. Remember the Bill of Rights was originally intended to protect state rights against federal infringement. Well, that was the argument in the dissenting side of living constitution, is that even if we were to directly interpret our Constitution as our founding fathers meant, at the time they were referring to protections for state rights, which would be a collective rights argument, which is a fascinating discussion. And if you want to take that through with your paper, I encourage it. It's a fun way to address this issue between the different interpretations of our Constitution through the District of Columbia versus Heller 2008 ruling. We will just revisit this in a few slides. I have a slide dedicated to this independently in which I can provide a more adequate discussion. But this ruling really revealed the differences between originalism and living constitutionalism, among many other rulings. And let's look at our current Supreme Court. Our current Supreme Court, it is worth noting that our textbook makes this argument, and many other works as well, that we currently have a conservative Supreme Court. Now, let me see if I don't have the page number in our text, but if you go to our textbook, the section on our Supreme Courts covers this argument. Now, 6 of our 9 Supreme Court justices were appointed by Republican presidents. This does not directly mean that they maintain Republican beliefs or conservative ideologies. But over time, we have seen a leaning for the majority of those representatives, those justices, to identify with conservative sentiments. And that is brought with a recent cluster of conservative rulings. Let me see, just to make sure, just to tell you the story overall about our Supreme Court justices, we have Chief Justice John Roberts, who was appointed by George W. Bush in 2005, who really plays a central role in the balancing of the court's conservative and liberal wings. We see him in that graphic to the right. He is the one under the conservative wing in the top left. He does represent this ideology, but has been, among all of these 6 Republican appointed justices, one that maintains the most restraint when it comes to representing his ideology on a hard line. So we see that is one of the reasons why he has obtained the post as Chief Justice and has maintained it quite well in many eyes. Now, we also see that there is Justice Clarence Thomas, one of the longest serving justice on our Supreme Court, appointed in 1991 by President George H.W. Bush, and is known as one of the strongest and firmest originalists in our Supreme Court. He strictly interprets the Constitution as it was written and intended to be written, interpreted by our founding fathers. Justice Clarence Thomas was called under national attention in recent years as some of his business travels were paid for by corporations that were a part of some of the trials he was providing rulings on. There's been a lot of conflict about that, and that has caught significant attention on the national stage. If you want to look into it, I'm happy to talk to you back and forth on how to navigate that issue. And it has really brought forward a lot of discussions about the ethical restrictions among our Supreme Court. Now, we also see Justice Samuel Alito, a staunch conservative. Alito was appointed in 2006 by President George W. Bush, one of the more adamant originalists as well. And now we move forward to Justice Neil Gorsuch, appointed by Donald Trump in 2017, the first Donald Trump appointment. He is known for his textualist approach to the Constitution, so he leans towards the perspective, towards the originalist perspective, but with a more constructive textualist approach. Justice Brett Kavanaugh joined the courts in 2008, also appointed by President Donald Trump, and has played a key role in some high-profile cases since. Also, originalist leaning in his interpretation. And another justice appointed by Donald Trump, the newest member, Barrett, was appointed by Trump in 2020, cementing a conservative supermajority, 6-9 within our Supreme Court, and once again representing the originalist approach to interpreting our Constitution. Now we see Justice Ketanji Brown Jackson, appointed by President Joe Biden, the most recent appointment to our Supreme Court. was the first Black woman to serve on the Supreme Court, and again, it represents not again represents the living constitutionalist approach to interpreting our Constitution. Another living constitutionalist, Justice Sonia Sotomayor, appointed by President Barack Obama in 2009, and is the first Latina on the court and is often seen as the voice for progressivism. And then finally, the last segment of the liberal wing, we see her in the bottom right, Justice Elana Kagan, another Obama appointee. She joined the court in 2010. Before becoming a justice, she was the first female Solicitor General of the United States, and that is the position that represents the U.S. government in the Supreme Court when there was a trial against the Supreme Court. So she had a lot of experience in that environment prior. We have had 2 presidents in U.S. history that have had the chance to appoint 8 Supreme Court justices, and those are Roosevelt and Washington, and that is primarily just due to the time. We have had a couple presidents in recent years that have had the ability to appoint 3 justices: Reagan, Nixon, and Donald Trump, and Truman as well. Eisenhower, Lincoln, and Harrison got to appoint 4. Don't have to remember those points. Oh, I accidentally skipped, but it is worth noting. So, this slide, which cases reach the Supreme Court? Well, the Chief Justice of the Supreme Court has the absolute power to determine which cases are to be heard. They hear about 80 cases a year, and our current Chief Justice is John Roberts. But it's important, the Chief Justice has the sole power to determine which cases are to be heard by the Supreme Court. All right, landmark rulings. What are landmark rulings? Well, these are rulings that substantially change the interpretation of existing law, oftentimes establishing a standard or a test to be utilized by lower courts in future rulings. A great example of a landmark ruling comes in Lemon v. Kurtzman when they provided the Lemon test. And that is a test, we'll go into this in just a few slides, but it's a test that determines if we have excessive entanglement between religion and government. And it has been overturned in recent years, but we will have that discussion very briefly. Landmark rulings provided by the Supreme Court that significantly influence how our written statutory law and our Constitution are interpreted. Now, this is where we're going to talk about some Supreme Court cases. I'm going to cover a handful that cover some of the most inflammatory issues. If you want to have continued discussion about these issues with me, I am more than happy to have discussions about them over email, phone calls, whatever it may be. Discussions on the Eagle Online. I really encourage you to have professional and respectable discussions if we talk about these issues. So, Roe v. Wade. This is a Supreme Court ruling that addresses reproductive rights on the federal level. And the argument within the ruling was that the U.S. Constitution provides a fundamental right to privacy that protects a pregnant woman's liberty to choose whether to have an abortion, and this relied on the Due Process Clause of the 14th Amendment. The 14th Amendment states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws." So, the concept of liberty that extends to it was the concept of liberty within life, liberty, and property that extends to individuals, families, marriages, and bodily autonomy. So that concept of liberty, remember, our definition of liberty in this course is your right to do and be whatever you want to do and be, up until you impede your neighbor's ability to do and be whatever they want to do and be. So it is basically arguing the liberty, restricting abortion on the federal level would be restricting the liberty of individuals, as these are individual decisions. So the ruling focuses on the protection of liberty under the Due Process Clause. So this is where we see a federal protections for privacy and healthcare, but it is important to note in recent years, this ruling was overturned in Dobbs v. Jackson in 2022. Their argument was that there is no privacy clause in the Constitution. So let me briefly go over to what degree we talk about privacy within our amendments of our Constitution. And this is, you can see this discussion in multiple places, in multiple textbooks, including ours. So the First Amendment addresses the right to privacy of belief and privacy of group membership. Our Third Amendment addresses the right to privacy of the home. That's the Housing Soldiers Amendment. So think about that's your right to have your privacy within your home. You do not have to provide your home to your government. Our Fourth Amendment protects unreasonable searches. So this is your right to be secure in your persons, houses, papers, and effects. So anything you have, you designate to yourself, your individual self throughout life is you have a right to privacy through our Fourth Amendment. Our Fifth Amendment provides a right to privacy in personal thoughts and documents as you, and this is again your right to not go against yourself in a court trial. Your right to plead the fifth, as many would say. Now, the Ninth Amendment protects your right. It has a protection of rights not granted in the Constitution to be left up to the states and the people. It says, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, end quote. So this is your rights. If it's not directly addressed within our Constitution, it is your individual right as a citizen of the United States. So, and since we do not have anything written in our Constitution, some argue regarding abortion, some argue that this amendment provides the right to privacy for all things not addressed by our Constitution. 14th Amendment, protection and privacy of personal freedoms. You cannot, quote, deprive any person of life, liberty, or property without due process of law. And the due process clause is what really standard as the foundations to the Roe v. Wade ruling. While the overturning in Dobbs v. Jackson was founded off of the argument that there was no clear right to privacy clause. Now, prior to Roe v. Wade, we had a couple of Supreme Court cases that did address the right to privacy. The most significant is Griswold v. Connecticut in 1965. This is the most important case where the Supreme Court explicitly recognized the right to privacy because they struck down a Connecticut law that prohibited the use of contraceptives by married couples, ruling that the law violated the right to marital privacy. In the opinion, the court resonated that the implied rights of various Bill of Rights guarantees, such as those found in the First, Third, Fourth, and Fifth Amendments, as we just covered, created a zone of privacy that protected personal decisions about marriage and family. And this was one of the foundational previous rulings that Roe v. Wade cited in their ruling in the 70s. But again, it has been overturned by Dobbs v. Jackson in 2022. Now, fast forwarding to the Lemon v. Kurtzman Supreme Court case. This is one I mentioned prior that provided the Lemon test, the general rule of thumb to be utilized by lower courts in the future. Now, the Lemon v. Kurtzman case addressed the separation of church and state by providing clear standards. This was a case where we had a football coach praying with his football team, actually praying independently on the football field after a game. And I'm sorry, that was the Kennedy v. Bremerton School District, where Kennedy was praying after football games on the field, and then he said it is his right to religion, and they ruled that they can overturn the Lemon test because under the Lemon test, they would have ruled that this is an excessive entanglement between state and religion, while he should still have the right to be able to pray on that football field. So the Lemon test provided three questions to ask yourself to determine if there is excessive entanglement. The first, does the law have a secular purpose? Secular purpose as in, does it have a purpose that is no relation to religion? Second, does the law's primary purpose, law's primary purpose may not inhibit other religions. It can't favor one religion or the other or inhibit any kind of religious practices. And then the third, the government must not be excessively entangled with religion. Is there excessive entanglement between the state and our and religion? I mean, one way to see this is through, government funding private schools that end up being Catholic schools. That was ruled as excessive entanglement. So Kennedy versus Bremerton overturned this ruling, and the Lemon test does not apply anymore within our court system. And the Supreme Court said, quote, history and tradition determines the scope of constitutional rights. That was an overturning in 2022, and this is one of the cases that signals the conservative leaning of the Supreme Court. Both the overturning in Kennedy versus Bremerton and Dobbs v. Jackson were both along those lines that we identified prior. 6 Republican appointed justices voted to overturn them. The 3 Democratic appointed justices voted to maintain the status quo. And without spending an hour discussing these cases, I'm going to move on because we have a handful to get to. Now, Plessy v. Ferguson. This is one you all remember, you've all engaged in 1896, this is where we saw an individual by the name of Plessy go to a protest against the Separate Car Act that was established in the 1800s. Separate Car Act is that it is constitutional to allow different races to be designated to different carts. You think of it on a railway, the different cars of a train. Now, Plessy purposefully protested this. Plessy was only 1/8 black and was one of the individuals at the time that could pass for either race. And he notified the railways that he was an African American individual and that he will be on the white railway, openly protesting, peacefully protesting, and eventually getting arrested. This reached our Supreme Court, and this is where our Supreme Court ruled 7-1 that it is constitutional to have things separate as long as they are equal. The one justice who ruled against it, John Marshall Harlan, stated, quote, "The white race deems itself to be the dominant race in this country," and later referred to the Constitution as colorblind. So this is the Judicial Supreme Court ruling that acted as the foundation that enabled separate but equal rulings within our federal government. Now this was, just like the other two that we've looked at in this course, overturned years later. Brown v. Board of Education overturned Plessy in 1954 as they stated, quote, "You cannot have legislation that is separate, that this is separate, but separate be equal is not adequate." I apologize. I got something in my eye and it really threw me off there. But Brown v. Board, the ruling we all know, separate but equal is not equal. I have on Eagle Online a video that really helps tell the story of Brown v. Board of Education. If I didn't have such a long lecture today, I would be covering it myself, of the individual the father who wanted to defend his child's right to go to a certain school that was much closer than the very far away school designated to African American individuals. Eye is no good. Excuse me as I struggle with my eye for a second. So this case we will briefly cover. I addressed in the last time I covered this course because it was a recent ruling. Wow, I'm just going to be crying out of one eye. Yeah, something in it. But this is the Students for Fair Admissions versus Harvard College. This is where the Supreme Court ruled in 2023 to end affirmative action. Affirmative action originated from the Civil Rights Act of 1964, originally founded through an executive order in 1965 by Lyndon B. Johnson. All right, I'm getting back into this. Now, this is where we identified a flaw in our educational systems, that we had many institutions that were not accepting African American students. So we enacted affirmative action. This, over the years, has been a tool to equalize civil rights processes in this nation, but in recent years has been identified as unnecessary, leading to the 2023 Supreme Court ruling in Students for Fair Admissions versus Harvard College. One second. And yeah, so we see that this resulted in a shift in how we apply for colleges. Previously, colleges were simply allowed to ask you, what is your race? So they can make sure they have various quotas to make sure that they have a diverse college environment. Now they are not allowed to ask you that question directly, but many students in the months after this case that wanted to make sure that these factors were evident and that it contributed to the challenges they overcame to become an applicant at the college. So now you see many students include race in their student essays, although there is a lot of debate whether this is an ideal avenue or an ideal approach, and we are still seeing the impacts of this ruling play out in how we apply for college. Some of you might have experienced shifts in the application processes. In addition to changing the fact that they can't have that question on the application, we see the shifts in the essay processes changing as well. The essay prompts provided have changed in regard to this Supreme Court ruling. So this Supreme Court ruling illustrates the breathing relationship we have with our government, and that we will implement things at times when needed to equal out civil rights, but in recent years this has been less required, and we have seen this result in a trickle-down impact that changes the way we apply for college even. All right, now I'm back in it. I got the thing out of my eye. I'm doing okay. But now let's look at Obergefell versus Hodges. This is a Supreme Court ruling in 2015 in which we provided a federal protection for the fundamental right to marriage. This was the 2015 is the year equal rights to marriage were truly provided within this nation. This is a landmark decision by the Supreme Court, and it guaranteed same-sex couples the right to marriage, as there was a couple who was married in a state they did not live in because gay marriage was not legalized in the state they lived. One of the individuals in this marriage had passed away, and they wanted the marriage to be officially acknowledged on the death certificate. And this Supreme Court ruling with a 5-4 decision resulted in them legally acknowledging their marriage on a federal level, and not allowing restrictions on who can marry who within this nation. This as well relies on the Due Process Clause and the Equal Protection Clause of the 14th Amendment, significantly changing how the relationship we have with each other in regards to the level the state respects those relations. Now, this is the other one we talked about, which revealed the differences in the originalist and the living constitutionalist sentiments within our Supreme Court, District of Columbia versus Heller. So this is where we see the Supreme Court ruling regarding private gun ownership in the name of self-defense. They ruled that you can have private gun ownership in personal self-defense, citing the Second Amendment, which says, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the divide is that there has long been a debate over the Second Amendment. Is this saying that we have an individual right to carry arms, or is this saying we have a collective right tied to state militias? Because remember, when this was written, we did not have a federal militia. We relied on numerous state militias that consisted of individuals with private gun ownership. Was this founded on the sentiment that we have the right to own guns because we must contribute to our state militias when need to make sure that we are not infringed upon by a tyrannical federal government? That is an argument about the meaning of this text originally, but you can also argue that your right to be a part of a state militia starts as your right to independently own a gun as an individual. So this argument can go both directions. But that's where we see the general divide within this hearing. Prior Supreme Court rulings on this issue were that U.S. versus Miller in 1939. This is a case where the court ruled that the government could regulate sawed-off shotguns. You've probably heard about this if you're into any mafia stuff. Under the National Firearms Act of 1934, because such weapons were not deemed to be part of the ordinary military equipment referred to as that our founding fathers were referring to, that would be used by a militia. This ruling was interpreted by some as focusing on the militia aspect of the Second Amendment, suggesting that the right to bear arms was tied to service in state militias rather than an individual right. So this is where you see the collective ownership argument revealed within a 1939 Supreme Court ruling. After Miller, lower courts largely upheld gun regulations and generally leaned towards the collective rights interpretation, which connected the right to bear arms with militia service rather than individual self-defense. And this was for many years the status quo. This is what all rulings were citing regarding national firearm ownership. Now, looking at legislation at the time regarding this issue, we see the National Firearms Act of 1934 that they cited in that Supreme Court ruling, which imposed taxes and registration requirements on certain firearms like machine guns and sawed-off shotguns, as we were seeing that the level of equipment in our militias, the machinery, the guns we owned, were developing in a way that our founding fathers had not predicted. And that was the foundation of these 1930s rulings. Now we fast forward a little bit to the Gun Control Act of 1968. This was passed in response to the assassinations of prominent leaders like John F. Kennedy, Robert F. Kennedy, Martin Luther King Jr., Malcolm X, and many others. This law regulated interstate firearm sales and expanded the list of people prohibited from owning firearms. So if you were a convicted felon, the Gun Control Act of 1968 made it to where you could not own guns. Now, we also have the Firearms Control Regulation Act of 1975. This law effectively banned the possession of handguns by civilians and required that all firearms in the house be disassembled or bound by a trigger lock, making them unusable for immediate self-defense. This Firearms Control Regulation Act of 1975 was in effect in the District of Columbia and stemmed as the foundation for this conflict, which resulted in this Supreme Court case. And now the story behind this case is Dick Heller, a licensed special police officer, was authorized to carry a handgun while on duty protecting a federal building in D.C. However, under the city's strict gun laws, he was prohibited from keeping a functional handgun in his home for self-defense. So Heller, supported by gun rights advocates, challenged the district's handgun ban, arguing that it violated his Second Amendment rights to preventing him from owning a functional firearm for personal protection. The D.C. Circuit of Appeals ruled in Heller's favor, declaring that the Second Amendment protects an individual's right to keep and bear arms for lawful purposes such as self-defense. So we saw the appellate courts they sided with Heller. Now, this decision was the first time a federal court struck down a gun control law on Second Amendment grounds, setting the stage for the Supreme Court's involvement. Because remember, the previous law was as listed prior, as read prior. And the argument for the majority ruling was that the term militia in the 18th century referred to all able-bodied men who were expected to bring their own weapons for military service, indicating that individuals had the right to own firearms. Even if it was a collective argument that we had the right to own firearms to be a part of a collective militia, it is that you have to first own them within the home to be able to use them as a part of a collective militia. And then we see over the years the NRA, National Rifle Association, founded in 1871, was developing throughout the 70s and shifted to a more aggressive stance against gun control, arguing that the Second Amendment protected an individual right to own and use firearms for self-defense. This ideological shift was driven by concerns over government overreach and a belief in self-defense, and that is where we see the current relationship we have with gun ownerships and the degree of regulation we allow by our government. So this again brings us to our question of originalists or living constitutionalists. And this brings you to a point where you can ask yourself a question. Did our founding fathers draft the Second Amendment with the focus on an individual right or a collective right? And that's where it gets a little fun to dissect the specific words of the amendment. And you can have various interpretations, whether you have an originalist or living constitutionalist approach. They are both adequate in many eyes. So this really, the main takeaway from District of Columbia versus Heller, it addressed the issue of gun rights and private ownership, in addition to revealing the divide between originalists and living constitutionalists. Now, what are the checks that the other branches have on the judicial? Well, we look at the executive, an important slide, of course. The executive has the ability to appoint the judges who work within the judicial branch. And additionally, the president can grant pardons, reprieves, and commutations to challenge the rulings of the judges within the lower courts. Now, and that is, of course, that would regard to federal cases if it is led by the president, but governors also have this right and can grant these things to, somebody just came in, and can do this on the state level. Now, let's look at the checks on the judicial by the legislative. They have the power to approve judicial appointments. The Senate has this independent power, and they must approve all appointments made by the executive. They also have the power to draft legislation that the courts must interpret. They write the statutory law that our judicial branch and judges must interpret and enforce. They determine the number of judges on the Supreme Court as well. We remember that discussion about the fluctuation, 6 to 7 to 6 to 9 to 10, now back to 9. Well, that was all led by legislative action within our legislative branch. And finally, just like how the legislative can impeach our president, they can impeach judicial members. They can impeach judges and justices. We have not seen a justice impeached, but we have seen many judges impeached in recent years. So these are the primary checks that the other branches have on the judicial. Now, we have a lot of takeaways we have to remember from today's lecture. We have to remember the general understanding of what issues were addressed in all of these rulings. We have to look at what Supreme Court rulings were overturned out of the ones we've looked at in this lecture. Remember, that would be Lemon v. Kurtzman, Roe v. Wade, and Plessy v. Ferguson. And we will look at who determines what cases reach the Supreme Court, what are landmark rulings. A lot of this is stuff you already know, or it bounces off of the previous question. So it may seem overwhelming, but I know you guys can do this. You guys can remember this content. I believe in you. Here are all of the answers right in front of you. And what's due this week? So we have our final quiz that is due by this Sunday, the 13th of October at 11:59. We also have discussion posts. That's the original discussion post because it is a odd number week. We have to respond to 2 classmates' posts due. I forgot to type it in. By Sunday, original post is due by Wednesday. You should know this by now. It's in that document I provided in the introduction of this course. Additionally, make sure you go through your readings, and we have our midterm next week. It is a midterm essay. It's a 1-page essay. There is a document on Eagle Online, again, illustrating every single requirement and what I will be looking for while I grade this assignment. So please reach out if you need help writing this page, this introduction. I will post a little PowerPoint right next to this in the lecture tab today that illustrates some just guidelines on how I recommend you go about writing your term paper and your midterm submission. So please reach out if there's anything I can do to help. Make sure you get that quiz done and your discussion post, and you get ready for next week's midterm. Thank you.